Good morning. My name is Jennifer Conklin, and I will be doing today's presentation on emotional support animals. First, I'll start with some background about elder law and advocacy and our programs. ELA is a nonprofit organization. We have offices in Claremont and El Centro. Seniors need to be at least 60 years old to be eligible for our services. We provide free and low-cost civil services, Medicare and Medi-Cal-related counseling and advocacy, referrals to community senior service providers, and community education. This presentation is put on as part of our Elder Tenant Assistance Project. As part of our Elder Tenant Assistance Project, we provide legal services to at-risk seniors to assist clients with landlord-tenant issues prior to litigation. I specifically provide legal assistance to clients with significant habitability issues. Today, we are going to discuss the Fair Employment and Housing Act regulations related to reasonable accommodations as they relate to emotional support animals. Providing this legal information does not form an attorney-client relationship, and the information presented today does not constitute legal advice. We always advise that you consult an attorney for your specific situation. The law governing reasonable accommodation requests can be found under the Fair Employment and Housing Regulations, Article 18 of Title II, Sections 12176 through 12185. The Fair Employment and Housing Act prohibits discrimination or harassment in housing and employment based on protected characteristics, and a disability is one of those protected characteristics. So, reasonable accommodations. A reasonable accommodation is a change or exception to a rule, policy, practice, or service that is necessary to provide an individual with a disability equal access to, use of, or enjoyment of a housing opportunity or dwelling. This includes an exception to a no pet policy. In order for an accommodation to be necessary, there must be a direct logical connection, or what's called a nexus, between the accommodation requested and the disability. You do not need to use the magic words reasonable accommodation in your request. So first, I'm going to start with the poll of what is an emotional support animal? Is it any pet, a trained animal that performs tasks to help someone with their disability, like a guide dog, or an animal without specific training that provides emotional support to a person with a disability? The correct answer is C. An emotional support animal is an animal without specific training that provides emotional support to a person with a disability to assist them in managing the symptoms of their disability. Emotional support animals are also referred to as comfort animals or just support animals. An emotional support animal is not a pet, and it is not the same as a service animal. Can housing providers prohibit a tenant or resident from having an emotional support animal? Housing providers are allowed to have rules regarding pets, and these rules include prohibiting pets, prohibiting certain types of pets such as large or wild animals, and prohibiting nuisance activity caused by pets such as incessant barking. However, if a tenant or resident has a disability-related need for an emotional support animal, the housing provider must allow the person to have the animal as a reasonable accommodation unless the housing provider can show that an exception applies. Can a housing provider request specific documents before permitting a tenant to have an emotional support animal? If the tenant's disability is not obvious or readily apparent, a housing provider may ask for documentation to support the person's request for a reasonable accommodation to have an emotional support animal. The tenant is not required to disclose their disability. The tenant only needs to disclose enough information to document their disability-related need for the emotional support animal. Some examples of reliable documentation include a tenant's own credible statement, or even documentation of receipt of disability benefits. Who else can provide documentation of a person's need for a reasonable accommodation? As I said, the requester, a licensed medical professional, a therapist, a social worker, the requester's parent, child, or relative, and the determination of whether this third party is reliable is determined on a case-by-case basis, and it will take into account how this third party is familiar with the individual's disability and/or disability-related need for the emotional support animal. Must the animal be registered or certified? No. There is no legal requirement that an animal must be registered or certified in order for it to serve as an emotional support animal. Businesses that claim to register or certify emotional support animals are charging for a service that's unnecessary to establish the necessity for a tenant's reasonable accommodation. Do online certifications or ID cards or tags or vests worn by an animal reliably establish someone's disability-related need for an emotional support animal? The answer is generally no. There are many legitimate licensed healthcare professionals who deliver services over the internet. However, an individualized assessment is required. An individualized assessment means an assessment that's based on information that demonstrates this individual tenant has a disability, describes the needed accommodation, and describes the relationship between the individual's disability and how the requested accommodation is necessary to afford this individual with a disability equal opportunity to use and enjoy a housing opportunity. Now I'm going to go over the reasonable accommodation request process. So the standards, procedures, and defenses for reasonable accommodation requests apply to a request to have an emotional support animal as a reasonable accommodation. Requests must be made by the individual with a disability or someone else authorized to act on their behalf. And the request can be made at any time, including in an application for housing. The landlord or property management's duty to provide a reasonable accommodation is ongoing. With limited exceptions, all information concerning an individual's disability, accommodation request, and medical verification must be kept confidential. These exceptions include if disclosure is required to make or assess the decision to grant or deny the request for accommodation, if disclosure is required to administer or implement the requested accommodation, if disclosure is authorized by the individual with the disability in writing, or if disclosure is required by law. The interactive process. So what is the interactive process? If a request for reasonable accommodation is not immediately granted, the recipient must engage in dialogue with the requester to reach a solution. This process must be timely and conducted in good faith. And if there's any insufficient information about the disability or the nexus, the person considering the request cannot deny the request without seeking clarification or additional information. Denial of reasonable accommodation. When can a requested accommodation be denied? It can be denied if the requester does not have a disability, or if there's no disability-related need for the accommodation, no nexus. If the accommodation would be a fundamental alteration of services or operations for the housing provider, if the requested accommodation would cause undue financial and administrative burden on the housing provider, or if the requested accommodation causes a direct threat to the health or safety of others, or substantial physical damage to the property of others, and the risk cannot be mitigated by another reasonable accommodation. A reasonable accommodation cannot be denied because it would be perceived as unfair to others, or it might become burdensome if extended to others. As mentioned, a reasonable accommodation can be denied if it would cause a direct threat. So what constitutes a direct threat? It must be based on an individualized assessment that relies on sufficiently recent and objective evidence. It cannot rely on speculation, stereotypes, or unsubstantiated inferences. So the assessment must consider the nature, duration, and severity of the risk, the likelihood that harm will occur, and whether additional or alternative reasonable accommodations will mitigate or eliminate the risk. So in the context of an emotional support animal, basically a reasonable accommodation for an emotional support animal can't be denied simply based on the kind of breed that someone's support animal is. There has to be an individualized assessment of that pet before deciding whether the accommodation will be granted or denied. Can someone have more than one emotional support animal? Yes. If the need for multiple emotional support animals is not apparent, the housing provider may request documentation verifying a disability-related need for multiple animals or additional animals. And the housing provider may consider whether the total impact of multiple animals in the same housing unit amounts to an undue burden or fundamental alteration of the housing program. And as we discussed, if it is an undue burden or fundamental alteration, then someone's reasonable accommodation request could be denied. Can a housing provider charge a fee or rent to have an emotional support animal? No. Housing providers may not charge someone with an emotional support animal a pet deposit, pet rent, or other fee or rent because of an emotional support animal. The housing provider may not require the individual with an emotional support animal to obtain liability insurance covering the animal, but the individual with an emotional support animal may be required to cover costs of repairs for damage the animal causes to the premises, but this does not include normal wear and tear of the premises. May a housing provider limit the breed, size, or weight of emotional support animals? No. Restrictions on breed, size, or weight of emotional support animals are prohibited, including those imposed by insurance companies. Again, as we discussed earlier, a determination of whether an emotional support animal is a direct threat must be analyzed on a case-by-case basis. For example, a policy banning tenants from having pit bulls is unlawful, but if a particular pit bull regularly growled or tried to bite other tenants on the property, the housing provider may be justified in denying the reasonable accommodation for this particular dog as an emotional support animal. What kinds of rules can the housing provider impose on emotional support animals? Reasonable conditions may be imposed on an emotional support animal to ensure it is under the control of the individual with a disability. Examples of these conditions include restrictions on waste disposal and animal behavior that may constitute a nuisance, incessant barking by an emotional support animal that may constitute a nuisance. The conditions cannot interfere with the normal performance of the emotional support animal's duties. Remedies for denial. If you are denied a reasonable accommodation for an emotional support animal, you can file an administrative complaint with the Department of Housing and Urban Development or the California Department of Fair Employment and Housing, and this will need to be done within 1 year of the incident. Alternatively, you could file a lawsuit in federal district court within 2 years of the incident. Additional tenant resources. Housing is Key provides resources for renters, landlords, and homeowners. Disability Rights California is another nonprofit which provides legal advocacy services to individuals with disabilities. The Legal Aid Fair Housing Center provides advocacy services related to housing discrimination. And I've also included the link for the Department of Fair Employment and Housing and the San Diego Lawyer Referral Service. This concludes our presentation on tenant rights, reasonable requests for accommodation related to emotional support animals. Please feel free to contact us with any further questions you may have.